With the final product of this?
The voters now have accurate representation of what they're going to be voting on. I think with one exception, I think that Senator Turner was right, that there should have been a change in the issue of allowing for additional licenses that can be provided beyond that 4 years, but we'll concede that point and move forward. This is about making sure that the voters have the ability to know and vote on legalization of marijuana for the compassionate care for the chronically ill and for adults who are 21 and older. They're going to vote on that in the next, 20 some or 40 some odd days. See, wow, I just lost 3 weeks.
Ian, do you believe that people are going to be more likely to vote yes as a result of the language today as opposed to the language that was in place a week ago?
Absolutely. What you had before them was fatally flawed. It was very clearly biased. It needed to be changed, and today it was.
What about the title? What's your reaction to that?
Well, I think the title, it's a shame that it continues to be misrepresented, but it is what it is, and we will live with it. I'm incredibly thankful that Justice Douglas and Don McTighe took a lead role in this, making sure that we could have the change that we had today, and we'll go on with the campaign.
Was that word used to elicit no votes?
Of course it was. Were you kidding me? Come on. Everybody knows that. Anybody that knows what a monopoly is knows that that's the lottery, knows that that's workers' comp. That's one. There are 10, they all compete against each other. The fact that the state can add licenses after year 4 if the demand's not being met for medical marijuana patients knows that that's not what we have today is not a monopoly.
And do you think you'll lose votes because of that language?
I think that we're going to be educating people about the fact that this board had to be taken to the Supreme Court and had to change what they just did today.
Is that an ad?
Could be. Stay tuned. There's more to come.
Justice Douglas, do you ever remember the Ballot Board being ordered to go back and rewrite language? I don't, but your memory may be longer and better than mine.
Mr. Johnson, we've had a number of those cases, but I have never, I think, seen one so precise and direct. And the spin is put on it that there's been a win on the other side. All I can tell you is we litigated 5 issues and won 4.
But there have been previous cases in your memory where the board was told, go back and redo this in some fashion.
And not to this extent in my recollection. This was so obvious that it's the only reason I got involved in the case, because it was pretty clear that what they had done, in my judgment, was intentional. It could not have been inadvertent or by mistake, given the language that was in the amendment and what they submitted, placed side by side. You couldn't arrive there inadvertently.
I take it you would disagree with the Secretary's assertion that these were technical changes that were made today?
I don't comment on what the Secretary says. What I do comment, however, is that I'm always amused when I hear the board and some other folks who spoke talk about what the court requested, what the court suggested. The court ordered, Mr. Johnson. The court ordered and said what they did was fatally flawed. That's pretty strong language.